Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya matinyana. Uya matinyana. Yeah. Uya matinyana. Oh, uya matinyana. Say, I call you Jireh. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. Will you make one cover? 1, 2, 3. I can breathe without you, say. I can breathe without you. I can move without.
Lovely people, another time is upon us for us to meet again and discuss things that will benefit you and the community. It's the community and the law brought to you by BWF Solicitors. This afternoon, we're looking at making a successful application where you would want to be exempt from the English language and life in the UK test. We understand, therefore, some applications you have to write the English language and also do and pass the life in the UK test. But what if I cannot do it? What if I don't have the capability to undertake these tests? Am I exempt? Who are the category or who are in the category of people, so to speak, that could be exempted from this? And how do we eventually make a successful application with that? Lawyer Bernard Owusu, Senior Partner BWF Solicitors, is our guest and resource person this afternoon. So let's get into it together. It's the community and the law.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community on the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, lovely people, and welcome to another edition of The Community and the Law. My name is Oreku Frimpon, and I have the duty and pleasure to be hosting this event and program for the next 2 hours. And this is brought to you by BWF Solicitors, our trusted partners when it comes to the law. This afternoon, we have a very interesting topic for you. And I know that when we talk about exemptions, people are excited because there are certain things we find quite difficult to do. We're talking about Life in the UK test and the English language test, which some categories of applications, immigration applications, need before they could be granted. Which are those? And we're asking if in any situation I am not able to write that or I've written it several times, I have not passed, would I be exempted from that examination in any case at all? Lawyer Bernard, who's senior partner of BWF Solicitors, Uncle Ben, we call him, will be taking us through that and also helping us to go through a very successful application. In all, I want to say that if you want to trust any law firm here in the UK, especially when you are looking at your immigration issues, any other family law issues, you trust BWF Solicitors. They are located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And you can call them on 0208 493 7340. 0208 493 7340. They have an office in Ghana, and those of you in Ghana, if you want to access any of their services, you can contact them on 055 589 5959. 055 589 5959. And in all emergency situations, you can text, WhatsApp, or call 077 127 61884. 077 127 61884. Exemption from English language and life in the UK test, making a successful application, is what we're going to look at. But before then, let's look at some of the things we want to update you on. We start off with a very exciting piece of news. What is that? During the week, we had a practice manager, a mom of the house, Madame Cynthia Brown, celebrating her birthday. We're so excited about that. If you have somebody who holds the family together and they have a special occasion like that, we all join in the happiness. So, Madame Cynthia, happy birthday to you. And it would excite you. Remember when we were looking at the Employee of the Month of August 2025? We had Madam Cynthia as the Employee of the Month. So a double whammy, I should say. Thank you very much, God, for blessing our mom and granting her another year. May the rest of your years that will be granted you in grace and favor be all the best for you. Congratulations on achieving the Employee of the Month of August 2025, and happy birthday to you. So I know you are smiling and it's so broad from left to right. We love you and we wish you all the best. Well, that out of the way, let's also get Gertrude's message that she sent to us during the week, showing her appreciation to BWF Solicitors for giving her the best of service. And she says, I'm incredibly grateful for the exceptional service I received from BWF Solicitors. From the initial consultation to the resolution of my case, their team demonstrated professionalism, expertise, and genuine care. The attention to detail and commitment to my case made a significant difference. Lawyer Bernard Owusu, Uncle Ben, was particularly outstanding, providing clear guidance and unwavering support throughout the entire process. Pamela also played a significant role for a positive outcome in my case. I highly recommend BWF Solicitors to anyone in need of legal assistance. You will never be disappointed. They are the best. Uncle Ben, if you were in Ghana, they would say phobia. They would say the best, but I know you are an Arsenal fan. This is Gertrude. She's satisfied. What do you say?
I think I'm also happy for her because of what her particular case was. It was a very sad case, really sad. You know, she came here as a visitor initially to come visit her mom with her daughter and return. That was her initial idea. As soon as she got here, she realized that the mom wasn't well. She was particularly affected by her mom's sickness and, you know, her daughter as well. So the understanding was that, what can I do to support my mom?
Okay.
And thankfully, her mom, you know, was an EU national. So we advised her to put in an application to stay so that she doesn't overstay, which then becomes difficult. But the problem is that because she's an adult, she needs to show that she's dependent on the mother.
Okay.
And unfortunately, her mom's situation is such that she doesn't remember most things.
Oh.
And she didn't trust anybody. And therefore, she didn't use apps. She didn't use bank transfers. All her transactions were done at the bank. So it was difficult to prove that she was a dependent. But her daughter was granted pre-settled status. Oh. She went to school. Lovely family. Kweku, the sad thing is that whilst we were preparing her case for an appeal, we lost her mom.
Oh, no.
So it became particularly difficult. And as you know, us, especially with community members, our passion is basically to get the law work for you. So we used the law to work for her. We went to an appeal. We won the appeal after a particularly difficult initial stage, and used the law as it's been couched to support her. And she won the appeal. Now she's here legally with her daughter. But unfortunately, she's lost her mom. Yeah.
Well, Gertrude, all that is well ends well. So we wish you all the best. And thank you for recommending that people should use the services of BWF Solicitors. They handle difficult cases, yes. And I recommend that people call BWF Solicitors 0208-493-7340 or 077127-61884. And you can visit all the social media platforms. The handle is at BWF Solicitors, X, YouTube, TikTok, Facebook, and any other social media platform you can think of. BWF Solicitors has the handle at BWF Solicitors. So thank you very much for joining. Those of you who have joined us, I would want to say, announce your presence. I'll be welcoming you. But there is an update I would want us all to catch up with. Record numbers of visa sponsor licenses revoked for rule breaking. You remember that on this program, and particularly for BWF Solicitors, we are passionate about this sponsor licenses, the skilled worker scheme, and all the other bits. We have taken our time on this very particular program to educate you on what to do, what not to do, how to go about things, and then also keep you updated when there is anything coming from the Home Office. The Home Office has done something, and we want to bring you up to speed on that one. Record numbers of employers have been banned from sponsoring foreign workers under a crackdown on abuse of the immigration system. Between July 2024 and June 2025, 1,948 licenses allowing companies to bring in migrant workers were revoked, more than double the number in the previous 12 months, which was 937. Improved data intelligence sharing across government and law enforcement has resulted in more employees being held to account for breaking the immigration rules. So how are people falling foul of that? Remember, those of you who have been following us, we have gone through how people go apply for their licenses, what is expected of them in the front office and the back office, and what services you need to provide, and what your obligations and responsibilities are towards people you have employed, and VS towards you as well. So I'm going to ask this very interesting question. What have people done wrong, Uncle Ben?
I think, we've gone over this several times.
Yes.
Consistently for 3 years. I remember when this whole thing started, allowing the healthcare visas to come in. That's what led to the explosion.
Okay.
My first caution was that it's good for the community. Let's look after it. It's greed.
Obviously.
It's greed. There's no explanation for anything else apart from greed. It's greed, it's selfishness. So you've got a business. You know that you can employ 10 people. Why do you bring in 20 people? Why do you bring in 30 people? And it doesn't make sense to me. It's never made sense to me.
Mm-hmm.
But above all, maybe you want to expand your business, which is fine. I've always touted one of my clients who started with one business. The turnover was just over $1 million. As we speak, the turnover is about 7.5 million. This week, we've just registered another business for. He's bought another business.
Okay.
And for me, that is somebody who is determined to use a system, follow the law to work for him. Because whether we like it or not, the system requires that people come here to work in that particular industry.
Right.
And as a businessman, and we've done this before, that if your focus is to have a 10-year plan, you bring in people, you know, for the next 5 years, they would dedicate their lives for your business.
Yeah.
They get indefinite leave. You know, whilst they are getting indefinite leave, you're also preparing to see whether you will have a transition where other people will come and replace them. Because it's not well paid. The job, it's not the best unless you've got extreme kindness in your heart to do that particular work. Unfortunately, the system was subject to abuse, and we all know what the abuses were. And for me, as you know, a couple of years ago, I was sitting and defend the businesses. Now I don't, because some of them don't listen. So, for example, I share updates with the businesses that we set up. You know, some of them, we set them up, they moved on, they felt they could do their own work up. I don't have a problem with that. But I shared freely with them. And one of the updates is that now the Home Office is closed so many businesses down that it's very easy for them to do a compliance audit. So what they're doing is that when you ask for COS increase, they will use that opportunity to do a remote mini compliance.
Okay.
So they write to you, you want to employ maybe 2 people, even 1 person. Okay, bring us your hierarchy chart, bring us your pay slips, bring us your RTR, bring us your bank statement, bring us your rota, bring us your scheduling, bring us evidence that you've got genuine employment. These people do not understand that once they've asked you for that, they're looking at the 5 duties.
Okay.
Reporting, record keeping, following the immigration rules, following UK laws, and integrity. So typical of us, and I say typical because so far I've gone through the list of business that has been shut down. It's either Africans or Asians.
Because we think and take things for granted.
And the sad thing is that people are still not learning, so they then send the information. Some of them, when they reach out to me, I say, well, be careful. I'm a lawyer. I work, so we charge for ourselves. It's not free.
Obviously, yeah.
So, and they will assume, oh, you know, some of them have got people in their back office to help them. They are not lawyers, I'm afraid. The industry knowledge that we have, that some of us have accumulated over 30 years, they haven't got. So whatever they do, you might think that you're speaking English. So they've asked you English. So you also want to respond with English.
Meanwhile, it's a technical thing.
Kweku, I can tell you that if 100 people are asked for that information, 90% of those will send the wrong information, which will lead to a compliance visit and a revocation. Because they don't understand. They don't understand their duties. They don't understand what the law says. They don't understand that you can't pay anybody cash. There has to be payment into bank account. There's so many things they don't understand. And they won't ask, and they won't take advice. Once they've got a license, they think it's an opportunity to make a lot of money. You can make the money.
Yes,
but you will lose it
in a day.
I mean, of course, they can go back to their own business. But for me, if you brought somebody here and there's been some agreement where it's been a transactional agreement and the person is not happy with you, they might pursue you for their money. And I'm now telling people who have lost money that they can either bring action against the people, whoever took their money, or if they've worked for that person or they are deemed to have worked for that person and they are sacked unceremoniously, without following due process, they should sue them.
Yeah.
And it's a simple fact is, how did we get here? We got here because of greed and selfishness.
So of the 1,948 licenses have revoked in the past 12 months, is there any way they could remedy the situation, probably get the licenses back?
Yes, I had a client whose license was revoked. So it was an initial assessment. Again, she didn't reach out. She reached out when it was too late. We worked hard and we responded. They went ahead and revoked her. We challenged them. We threatened to go to court. After 3 weeks, they wrote to us, apologized, and reinstated their license. But it's because we got involved very early. I'm not saying that when we get involved early, it solves the problem. All I'm saying is that if you do the right thing all through, you may make some mistakes. Even if it's a minor mistake, they will revoke you. But where you make mistake and it's not an intentional error, but it's an accident, then you can rectify it. Because, for example, if you've got 5 people working for you, they want to see the rota for the week. You should see all the 5 people on that rota. Or in a month, you should see all the 5 people doing their 37.5 hours or 40 hours, and they should be paid. And the pay should go into their bank account. And you should have an RTI, because these days, if you have employers and you pay them, it's registered on the HM Revenue portal. It's a real-time information. You can capture it. If you've got more than 100 staff, sometimes the documents we go through is about that much. Yeah, we go through. There's one that I just pulled the documents from April yesterday because she called. And what I realized is that there were issues with some of the RTIs, because we need to match the RTI to the bank statement. The payment is done in bulk. So some people authorize their bank. You will see that maybe 100,000 has gone out of their bank account, but it's to individuals. So you calculate the number of individuals, let's say 100 people. You divide 100 by pay slips that you've got. And quite cool. It's a laborious task.
Yeah, it will
and we need to be very meticulous, because you're dealing with somebody's business. We need to make sure that it works for them. Because what I know is that if you have migrants who you sponsor working for you, they give it their all.
That's right.
That I know, because it's a reciprocal arrangement. They work for you 5 years, they get their indefinite leave. You pay them on time, you pay what you say you will pay, and make sure that you're also complying with the law. And because you're not a lawyer, always have a good lawyer by your side, where you can call them day, evening, afternoon, night, dawn, morning, anytime, for them to respond and give you the services. So Kwaku is greed and selfishness.
Well, as it is, between July 2024 and June 2025, 1,948 licenses allowing companies to bring in migrant workers were revoked. This is more than double what was in the previous year. And I believe if we don't do the right things, in the next 12 months, there will be more. And probably the opportunity that we have may be taken away from us. So a word to the wise is always enough. But if you need any assistance, if you need any support for setting up your organization and also running it properly, you need support from a lawyer. BWF Solicitors are specialists in this one, and they'll help you. 0208 493 7340. Well, another update that came earlier this month is the family reunion route closed under Home Office new law HC 1298. The family reunion route has been suspended from the 4th of September 2025. This affects refugees in the UK who wish to bring their families, including partners and children. This, in effect, is in response to the abuse of the process at the Home Office has stated that they are introducing a temporary pause to appendix family reunion that is sponsors with protection as they undertake a full review and reform of the current family rules to ensure they have a fair and properly balanced system. It is important to remember that there are other options for those affected to bring their family. So if you would want any support for this one, speak to our experienced lawyers and they will help you. I have always said, and I'll repeat, the numbers are 0208-493-7340 or 077-127-61884. The key term here is suspended. So obviously, as the text goes on to say, it may be brought back, maybe set out differently, or probably properly tightened, so that if there was any loophole, you would not have the chance to go through it. I guess I'm right, Uncle Bert.
Yes, quite cool. So, as you can see, our donor was here, and our donor advised our government that it should use the army to clamp down on illegal migration. I think the biggest problem is the channel crossing, where you've got people packed in dinghies, and they come all the way from France to the UK. So that's what is causing the problem. And for politicians, it's a hot cake, because our friend Nigel Farage, who is now on a crusade, and his crusade is illegal migration. And, you know, our dear sister, Kemi Olushola, she's not finding her way, so unfortunately, they're not doing well. So it's a subject where every government wants to appear tough. So Tony Blair's popular refrain was, tough on crime, tough on the causes of crime. So tough on illegal migration, tough on the causes of illegal migration. Today I was listening to LBC, and all they are talking about is this problem. One in, one out. Bug off, buy one, get one free. Now the problem we have with this is that a lot of these people are coming from war-torn countries. Afghanistan, and now Palestine, and other countries. But within the mix, you've also got people who are economic migrants. When you take asylum claims, over 60% are successful. And when it goes, those that are refused, when they go to court, I think about another 30% are successful. So in the scheme of things, majority of them are genuine refugees. Once you're recognized as a refugee, it gives you the chance to bring in your family. And that's why it's called family reunion. And again, that increases our numbers here. And because if one person is allowed to bring 5 children and a partner, one person is now plus and that increases. And nobody's talking about net migration again, because it's a number that is unachievable. But the focus is to appear very tough and effective. For me, what I've identified over the last 33 years of working in this industry is the delays at the Home Office. So the Home Office is blaming the courts. They've changed the court system, where an adjudicator now listens to an asylum application. The turnaround time is about 54 weeks. They've now brought it down to 24. They're setting a panel system. We used to have a panel system where when you go to court, you meet the panel. Some of whom are lay panel members, and maybe one person who is a judge. You still have that at the upper tribunal, but I think these days, even upper tribunal, all of them are judges. So it's just to make sure that they reduce the number. They put in the word temporary, because family reunion is under the UNHCR. Because if somebody is a refugee and you accept that they have a fear of return, a genuine fear of return to their country of origin, then if their family is there, you can't separate them. You need to reunite them. And that's where we are. Temporary, some of these things, they start with being temporary. And then because it takes a long time, but it doesn't mean that those people cannot come. What it means is that they cannot use the asylum route, which is free, to come. Because the reunion is a system in place that is supported by the United Nations High Commission for Refugees. So they come, they don't pay anything, they just come. But you can apply for them to come here as your family member under Appendix FM, which means that you pay the Home Office fee and everything. So they still can come, but you need to show. And some of these people are not working. Or if they're working, they're not earning 29,000. But if you're applying under the immigration rules, then you need to earn the income that the law says that you must earn. it's a tough thing. I mean, refugees. We usually don't have many refugee applications because Ghana, there's nothing there. I mean, in the 90s when I started, the about 80% of the applications we did were for refugees. People were running away.
Run away from Kunitas and the rest of it.
Yeah, but now it's, you may have one or two um, sexual orientation based, but normally applications from Ghana as a refugee, it's not successful.
All right. Well, it's suspended, but as Uncle Ben said, you can apply under the FM route, and you may be successful if you do the right thing, but it comes with a cost. So when the suspension is lifted, we will let you know. And if you need any further support, as we said, contact any of the experienced lawyers or BWF Solicitors. You can book an appointment on 0208 493 7340, and you will be supported. We're going to look at our nuggets for this week. I always say that look out for our nuggets Monday morning, probably before midday. And there's something that we will put out for you to look at and learn, and also arm yourself when it comes to the law. We're looking at, a long-term physical or mental health condition which may exempt you from passing the English language and life in the UK test. This will dovetail into our discussion this afternoon. Let's go through it. You can request an exemption from the knowledge of English and life in the UK, that is a KOLL requirements. If you have a long-term physical or mental health condition that permanently prevents you from meeting the standards for learning English or taking the life in the UK test, you must provide evidence from a medical professional using a waiver form, that is waiver form KOLL, which shows how your condition impedes your ability to pass the tests. Your GP or treating consultant must always complete the KOLL exemption forms, explain your condition in detail in a cover letter, and add copies of your medical records to confirm that your condition is long-standing. This is a discretionary provision in the law. Supporting application with independent evidence is always advisable. Would also say that the exemption for a medical condition is assessed on a case by case basis. We picked this from 6 and Schedule 1 of the British Nationality Act of 1981, paragraph 2E. For this, I'm not going to ask Akiba to give us an explanation because, as I said, it dovetails into the discussion we're going to have. But I want to invite you to send in your questions or concerns via text 07399208468, or you can call in when the lines are active on 0208 493 7345. 0208 493 7345. So let's look carefully, and when we would have finished with the discussion, I know definitely you will have an answer. But I'm going to give you my scenario, which is in the form of my test, and I will come after the discussion to ask you what our friend in this scenario would need to obtain. His name is Greg Afonso. He has suffered from anxiety and depression for over 10 years. He treats this condition with prescribed medication and recreational activities. His medical condition makes him anxious under stressful conditions. This makes him forgetful and anxious. Greg is applying for British nationality, but is anxious that he will not pass the English language and life in the UK test. What must Greg do for the Home Office to waive the English language and life in the UK test requirements for him? He needs to obtain the following: 1, completed waiver forms and a cover letter from his GP or treating consultant; 2, completed waiver forms and prescription; or 3, doctor's letter and cover letter from his lawyer. Think about this. I'll bring it back again, but I will want to quickly say thank you to BWF Solicitors for allowing us to, 1, use their platform to educate ourselves; 2, giving us the opportunity to enjoy good and professional services that guarantees us almost 100% success; and then again, being a friend of the community. Our resource person and guest is a senior partner, Uncle Ben, We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay. Welcome back, and thank you very much for sticking around. It's going to be an interesting and exciting discussion, and I know that people would want to know how we could get exempted from writing the English language and life in the UK test. Nuggets actually outlined some of the things that need to be looked into and looked at when we're looking at getting ourselves exempted from that. But then we need to unpick it, start from the very beginning, what life in the UK test is, what the English language is, which kind of application that we need to have the life in the UK test and the English language go to complement that, so we will be successful and the rest of it. I mentioned earlier on that our resource person and guest is a senior partner of BWF Solicitors and with us. Unfortunately, we didn't have the chance to properly welcome him because we had things to throw at him, and he has gracefully answered all that and given us some education and advice. So at this point, with all your permission, can I please welcome to the show and the program, the community and the law, the senior partner of BWF Solicitors. If he was in an auditorium, we would have asked you to give him a round of applause. I'm very proud to. How are you doing?
I'm doing absolutely fine.
I'm so grateful to have been able to pull you away from your Saturday family chores, because it's not easy to get to. Sometimes we have to catch you on a flight. Sometimes we have to get you out of the gym. Sometimes we have to get you off your TV when our sound is playing. So we're grateful that you are here. Thank you for being here.
Thank you very much.
We're looking at exempt from life in the UK test. Knowledge of life in the UK, that's the technical name for it, and the English language. Why do you have to get these to make any application at all?
Okay, so when the UK government initially introduced knowledge of life and language, the emphasis was on integration. So what the UK government, and I think it makes sense, that if somebody wants to stay here, they should be able to speak our language. And the language we have here is English language. And you can only know whether the person can speak the language if you test them.
Okay.
Now, there's a difference between going through the process and setting a bar, because the bar is very high. My B level B1 is really, really high. And not many people can pass, even those who are educated to as high as secondary school, Form 5, or ZJSS, SSS.
Senior high,
Senior high. You know, sometimes it's very difficult. But I've always said that for the English language, my test is my mom. And I've always said that if they put B1 there, my mom will pass. And my mom is not lettered. So she's never had a formal education, nor sat in a formal classroom. She educated herself, you know, a long time ago. So it's not particularly difficult because it's conversational.
Okay.
But the emphasis is on integration. However, it's not only English, it's knowledge. And the knowledge is computer-based aptitude test. That is where the difficulty is. And most people, including people who have finished university, have failed. I know people who have sat and not passed.
Is it because they are anxious or they don't know?
The questions can be tricky.
Okay.
The questions can be tricky. I mean, if we have time, we'll pull some of the old questions for people to try their hands on. So for people who have lived in this country, who are on a trajectory to first class, which is a British citizenship, it's not only British citizenship that requires the knowledge and language, but also indefinite leave to remain.
Okay.
So if you don't pass those two tests, then you will not get indefinite leave to remain. They will leave you on 2.5 years, which means that every 2.5 years you have to go and pay. Now it's about £3,903.50 every 2.5. That is if it doesn't go up. Yes, you can apply for fee waiver, but also it's a restriction on you. If you want to go to university, it becomes a problem because you haven't got indefinitely leave the UK for longer than it's necessary. You may lose your right to remain. And even for if you're subject to no recourse to public funds, you cannot access public accommodation or social accommodation, which is a council or a housing association. So it's important that people understand how they can get over this particular hurdle. For us as lawyers, what we always tell people is that, can you make the effort? If you can make the effort, then that's fine. But we all know that not all of us are educated. We have more uneducated people here than educated. And those who are not educated, who cannot write, who cannot read, very unlikely that they can pass the life in UK test. And it's a problem because you want to help them as much as possible, but then they don't have a disability, a physical or mental condition or medical condition. So it becomes a problem. And that is why we want to focus on how you can get over this hurdle.
Okay.
First of all, there are broadly about 3 exemptions.
Okay.
There is age, there is country you come from, and then there is the physical, medical, or mental condition. So the age, if you're 18 and below, you don't write English or life in the UK.
Okay.
If you're 65 and above, you don't write the English and life in the UK.
Okay.
So those are set in the law.
Okay.
And then there's a discretion. And then the discretion is what we are part 3. So when you look at appendix knowledge of life in UK, let's go to the top. This is the immigration rules. It was last updated on the 4th of September. So it's very current.
Okay.
Now it says that immigration rules appendix knowledge of life and language. When you go to part 3, that's what talks about the exemption.
Right.
So you can see the exemption. I've mentioned 18 years, I've mentioned 65. And then the third one is where the decision maker considers that. Let's pause there. Once they use the word considers, it's a discretionary provision.
Okay.
So you will have to convince the caseworker that, one, it will be unreasonable to expect you to sit and well,
pass.
not only that, to learn, to
Okay.
sit, and to pass.
Okay.
Let's read C. Ekweku, you are the English person, so please read it for us.
Well, it says in all the circumstances of the case, the decision maker considers that because of the applicant's mental or physical condition, it would be unreasonable to expect the applicant to fulfill either or both parts of that requirement. 3.2 says, in the following circumstances, an applicant will be deemed to have demonstrated sufficient knowledge of the English language and about life in the UK.
We don't need those.
We don't need those ones.
Yeah, so we want to talk about the exemptions.
Okay.
And those are the C.
The C.
So our focus today is on C.
Okay.
And please, those of you who can read and remember, we will do something today because there's a bit of case law, but I'll try and break it down to lay persons. You see, look at the word in there. What they said is that if it appears to, or if they consider, or say, I was say the manner. Into we Ghana and Kaya because greasy palm. Sorry, I was speaking my local language.
So it means that the threshold is not really too high.
Well, the threshold for you to be considered as an exempt person is not particularly high.
Okay.
If you meet the test.
The test, okay.
Now, when we go to the words again, let's go there because the guidance note says something different. Okay. And I'll explain why the guidance note is a problem. And that is why we've brought in the law. This is the law.
This is okay.
It has either gone to immigration rules, Immigration Act goes to Parliament. Immigration rules sometimes goes to Parliament. Not all immigration rules are laid before Parliament. Okay. This has gone to Parliament. The law says in the case of Alvi, in the House of Lords case of Adelola, and then in some other cases, that the immigration rules is a set of statutes. Statute means it's been passed by Parliament. The guidance notes, which is an explanatory statement or an explanation of what case workers do to assess your case, is not law. But if it gives you an advantage,
you don't refer to the law.
Then you don't lose that because you will have legitimate expectation. That's why the courts have said in the case of Alvi, in the case of Adelola, and in a couple of other cases. Adai, let's go back. There's a reason why I'm doing that. Okay. So once the law says that if in the circumstances of the case, the decision maker considers that because of the applicant's mental or physical. So we know mental will be things like anxiety, depression, any mental health problems. And then physical might be blindness, might be speech impairment. It doesn't, when you go to the guidance notes, it lists
the situations.
It lists a couple. Okay. But it's not prescriptive. Okay. So it hasn't listed everything. So what is mental? I think we all know what mental. But what is a physical condition? Does it mean that if I can't walk, it means I can't do the test? What about wheelchair? What about mobility? Does it mean that if physically, I've got some challenges? Yeah. Is that what it means? For instance,
I can't hold a pen properly.
I can't
maneuver the mouse.
Or I can't use a mouse. Yeah. What does that mean? Let's go to the guidance. And the guidance will be the technical team. If you look at the guidance notes that was shared, it will say it will be the one before the case mine. Yes. And let's click on exemption. Exemption because of physical or mental condition. So this is the exemption. Kweku, I'm going to task you to go through gradually. Okay. Yes, I click the exemption again. Okay, yeah, it's there. Kweku, let's go through gradually.
Okay. So it goes on to say this page tells you when to exercise discretion.
So we know it's a discretionary power.
That's right.
So it's not mandatory that you should refuse it.
Mhm.
It's discretionary.
Yeah.
Let's go on.
And waive the knowledge of language and life in the UK requirement because of a physical or mental condition to a person applying for naturalization as a British citizen or indefinite leave to remain.
Kweku, when you read that and you remember the statute we read, it's word for word, it replicates it. There is no qualification on the physical condition being long term. And there's no qualification on the mental condition being long term. Let's read. Let's go on.
There is discretion to waive the knowledge of language and life in the UK requirement if, because of a person's physical or mental condition, it would be unreasonable for them to meet it.
Now, unreasonable has first been introduced. When you read the law, did it say unreasonable?
No.
It didn't. So what is this? It's an advantage to you. So when you make your application and you state your mental or your physical condition, which has been backed by your GP or a registered general medical council physician, and he says that in his opinion, you cannot read, prepare, write, and pass these exams. That is a medical person.
Yeah.
And that it will be unreasonable to expect you to read, prepare,
and
sit, write, and pass.
Yeah.
So they've given you advantage. Let's go on. Let's go down slightly.
Yes,
Let's go
this is
down.
set out in that appendix KOL of the...
Let's go down. No, leave the one. To request when to exercise discretion.
Okay. So you must exercise discretion if the applicant is suffering from a long-term illness or disability that severely restricts their ability to learn English or prepare for the life in the UK.
Kweku, what's happening here?
They've introduced the...
So they've increased the threshold.
Yes.
Now the threshold is not mental or physical impairment or physical, mental or physical difficulties. What does it say now?
It says a long-term illness or disability that severely restricts their ability to learn English.
When we read the law, did it say long-term?
No, it didn't.
So it means that if today I have a mental health problem, and for that reason, it will be unreasonable for me to prepare and go and pass the test. And it's today, or it's a week, or it's a month. Month is not long term.
The caseworker would say no.
This is telling the caseworker that it must be long term. Now, we know from the case of Adelola, we know from the case of Alvi, which is a Supreme Court case, they all say one thing, that the law is the law. Where the law says that mental and physical disability, and it doesn't say long term, if somebody comes with a mental or physical disability,
it changes the threshold,
and says that the doctor says that for the past 1 month I have been, you're not going to say, well, my guidance knows that it should be suffering from a long term, because the word long, potentially we're looking about a year plus, but the law doesn't say that. That's a reason why we're doing this, because, you know, sometimes we just take home office decisions just like that and we don't challenge. Kweku, go on, read again.
So the second bullet point says, I'll add the an intro so that it makes more sense. You must exercise discretion if the applicant has a mental condition which prevents them from speaking or learning English to the required standard. So where a person provides evidence that they would be unable to satisfy one part of the requirement, it does not automatically mean that they will be unable to meet the second part of the requirement. It may be that their condition would make it unreasonable for them to prepare and complete their life in the UK test, but due to the different nature of how English language is assessed, they are still able to demonstrate that they satisfy the English language requirement.
Let's go to how to exercise this.
So then, how do we exercise our discretion? You must consider how the condition would prevent the applicant from taking the life in the UK test or learning English. For example, discretion may be appropriate where an applicant is deaf,
physical,
is a person without speech,
physical,
has a speech impediment which limits their ability to communicate in the relevant language,
physical.
Each application must be considered on its own merits and will depend on the facts in each case, including whether the applicant is a national of a majority English-speaking country. Live in the UK test centres and many colleges can cater for a variety of disabilities such as blindness. An applicant may be able to do the test even if they produce evidence of a disability. You have changed the threshold again here.
Of course, they have.
You must also consider whether an applicant's condition would prevent them from meeting both parts of the requirement or just one. Well, he continues to say evidence of physical or mental condition. I think that's where we're going to apply a lot of strict test and proof to this, isn't it? If an applicant claims to have a physical or mental condition, they must provide original and current medical evidence from a medical practitioner. This must include the medical waiver pro forma, where a request for an exemption does not include a medical waiver pro forma completed by a relevant medical practitioner. You must provide the applicant with the opportunity to provide this unless the application falls to be refused on another ground. Where an applicant fails to provide a completed waiver despite the document being requested, you must consider whether they satisfy the knowledge of English language and life in the UK requirements based on the information available. Any refusal must make it clear that they do not meet the language and or life in the UK requirements and have not provided the specified evidence to be considered for a waiver from these requirements. It continues. Applications which are not subject to specific medical waiver evidence requirements. You cannot insist that an applicant seeking a waiver provides a medical waiver pro forma completed by a registered medical practitioner. When you are considering an application for naturalization submitted before the 9th of August 2018, indefinite leave to remain application submitted before the 1st of November 2018, settlement under a simplified route made after 1st December 2020, skilled worker representatives of an overseas business, T2 Minister of Religion, T2 Sports Person, UK Ancestry, Global Talent, Innovator, T5 that's temporary worker, international agreement workers who are private servants in a diplomatic household, Hong Kong, British national overseas. If the application seeking the waiver fits into one of the categories above, you must consider whether the evidence provided of the applicant's condition is sufficient to exercise discretion.
Thank you, Kweku. And clearly, we have a challenge. So the law is very clear. The law simply says that mental or physical condition that prevents the person from preparing and passing the test. That's the law.
That's the law, yeah.
And then the guidance note says that if it will be unreasonable for the person to prepare and pass the test, so that's extra advantage. So that one we will take that. We like that. Thank you very much, Office. But then he introduces a very high threshold of long-term illness or mental health or physical. And for me, if they refuse you because they say, well, it's only recently that you've got this problem or challenge, it's not long-term. You can challenge them.
Yeah.
Because where the law is very clear and they've increased the threshold, you can always challenge them on the basis of case law, that the guidance notes on which they've relied is not part of the statute. And if the immigration rules are advantageous to you, the guidance notes, which is just a guidance note, cannot take it away from you. However, where the guidance notes gives you an advantage, and in this case, they've given us an advantage of unreasonable. So you're saying that, well, maybe my challenge doesn't really meet the test, but for you to expect me to go through the process, because they've added that in certain instances, if you have a physical challenge, the test centers have facilities to support you. But you're saying, no, it's unreasonable to expect me to go through this particular procedure for me to pass because of my physical, mental, or medical condition. So it's an advantage. Ladies and gentlemen, I nearly shared a medical center that specifically does this, but I'm not, because I don't want to promote any business, which may be, of course. If somebody goes there and they don't pay, they say, Uncle Ben, you are the one who told us to go there, and now it didn't work. And, you know, so we will stay here. But if you're struggling to pass the exams because of a particular physical or mental condition, and I will crave your indulgence to list the few that we've worked on. One, anxiety. So we had a client who is a very anxious person, and the thought of passing exam. She came here in the 80s, but she's anxiety is a mental health issue. There are many people with anxiety in the UK, and even at our universities, the universities will give you more time to prepare or write your exams if you have a particular condition. So she had anxiety. The thought that she was going to write the exams, you know, could put her, you know, in such confused state that she becomes very aggressive. She can't sleep. She won't eat. And it causes a lot of problems for her. She works, but she works part-time because she cannot take stressful situations. So when we initially applied, they came back and said, oh, you know, this is, she's got anxiety. So we then wrote to the GP. And that's where lawyers come in here. The lawyers must always guide the GP. And technical, if we can show the pro forma. So the pro forma asks specific questions, but we always go far and above those specific questions and add the notes, the medical notes. And so this is the waiver for KOL. And the latest version is 11/2018. And these are the questions that they ask you. Let's pause there. This form to support a request for waiver from knowledge of language and life in UK requirement for a person applying for settlement or naturalization. And it says that it must be completed by a General Medical Council registered medical practitioner. So first of all, there's a qualification there. I mean, the law didn't say General Medical Council. It says relevant medical practitioner. That's, again, is an issue. Maybe it is, maybe it's not. But that's not my focus. So you see, it asks the medical practitioner specific questions. In your professional opinion, please state. Now, he's a doctor. Caseworker, you're not a doctor.
Yeah.
Why are you going to challenge this person who stated a professional? You see, I don't understand.
Yeah.
So they say, they didn't say in your ordinary,
He's a professional.
in your doctor, medical doctor, what is the nature of this person's condition? They will state it. 2, how does this condition impact on their daily life? They will state it. 3, let's go, technical team. How will this condition prevent them from learning English? There are a number of ways to learn English, including classes and home study. The language requirement for citizenship and settlement is only for speaking and listening, not reading and writing. So they're just clarifying that they're not going to read or write. Because they will have to read for life in the UK.
Yeah, obviously. Yes.
And if they are learning English and they've gone to school or they're taking, they will have to read. So why are they saying, so that's not true. So how would this condition prevent them from learning English? So the GP will have to say that in my professional opinion, having assessed this person, they don't have to be your GP. It can be any doctor that you've gone to see. I am of the opinion that this particular condition will prevent them from learning or passing the English. Number 4, how will this condition prevent them from studying for the knowledge? So the English one is different because the test is different. With the study materials are available in number of formats. And so what? Including audio. And so what? The person...
But that doesn't stop them from being anxious.
That's correct. So he will have to say that in spite of the fact that there are study materials available in different formats, and we guide the GP to say that, I am still of the professional opinion that having assessed this person based on these questions, that they cannot read and pass the exams. 5, how will this condition prevent them from sitting the knowledge of life test or taking an English test? Knowledge of language life in the UK can be taken in audio form, and the test centers can cater for. It's a computer-based. He will have to say that in my professional opinion, and that is all they need to keep saying. You need to keep repeating. So before they go to the GP, we will write a letter for them. We just don't give them this document. We'll write a letter that, dear GP, we are representing this person in relation to the application for indefinite leave to remain or British citizenship. As part of the application, they will need to prepare, learn, and pass. We've been instructed that our client suffers from anxiety or memory loss, and that over the last few weeks, they've seen you and you have prescribed medication or recreational activity to support them. Can you answer the following questions in your professional opinion? Can we also emphasize that when you begin each answer, please state the following, that in my professional opinion. You can, unless they go and bring another doctor to assess you, they shouldn't be able to challenge the doctor.
Yeah, but they're professional and they'll be certified.
That's correct. Let's go to the last. In your opinion, so now they've stopped the professional opinion. So now they're saying, in your opinion, is the condition likely to improve in the next 2 years? You see where they brought in the long-term illness. Why have they brought in 2 years?
Because now they're defining the period.
And for me, this is where the problem is.
But this is not the law.
That's not the law. So we also add that on question 6, there's no requirement for you to state that they will get well or they can recover within this period. The law says that if they have a physical condition, and for us, that says that the present, if they cannot pass the present, you don't have to respond to the next 2 years question. In what capacity have you dealt with this person? For example, a GP, consultant, or other medical profession. So it doesn't have to be only your GP. It can be a consultant. It can be a medical professional who is only seeing you to diagnose you for this particular condition. And then 8, have you worked professionally with this person other than for the purposes of this report, and over what period? You see, again, they want to introduce the long term. You can explain that I have worked professionally with them for this purpose. Nothing prevents you from saying that. And then you state your medical qualification and registration number. And then when you go down, you sign the forms and you state your GMC number. Let's go down. Go down. That's it. Okay. And state your professional qualification and any registration number. You put it there, and then that's it. So, Kwaku, this is where we are. And I hope that those of you who have some form of anxiety, mental health issue, memory loss, forgetfulness, early onset of dementia or Alzheimer's, somebody who suffered from stroke before, very likely it affects your memory, or have some physical condition which prevents you from reading and preparing for the exams. If your GP is not helpful, when you go online, there are other registered GMC council members who specifically write reports, and you need to have a lawyer to help you to get over this. I've had instances where somebody's brought a medical report from a herbalist, a herbal clinic in Ghana. Their lawyer that they had made this application using the herbalist report. And Kweku, don't laugh. I don't know whether the person was preparing Alafia bitters or Adonko bitters, but the herbalist said in their opinion, this person cannot pass the exams. The person took the report to the GP, and the GP also followed the same format. What a GP should have done was to throw away the herbalist report
and write it for themselves.
Home Office went on the website, they went on the internet and searched for that herbalist, and they wrote back to the person and told the person that where you you had this report written, the person is not a medical doctor, is a herbalist, so we're not going to accept this report. I've also seen people go to psychologists. No, not psychologists, but a medical practitioner who is registered with the GMC. So I hope this is helpful. But again, if you want to answer, ask questions, you can always call us into the studio, and we'll be very glad to help you.
Call me to help you ask your question. I am not a herbalist. I'm not a medical practitioner. I'm a media person. Anyway, you can send in your text 07399208468, or you can call in 0208493745. We're taking a quick break to say thank you to BWF Solicitors. Remember, they're on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, North London. We work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208-493-7340. Now, this afternoon, we have been looking at exemptions to the Life in the UK test and the English language, the KOLL, Knowledge of Life and Language. And Uncle Ben is taking us through the law and the Home Office guidance as to how you could be exempted or not. Your questions are welcome. Put them in the comment section down below, either on Facebook at BWF Solicitors and at BWTV UK, both on Facebook, as I said, and YouTube. Or you can send it via text to our text and WhatsApp number 07399208468. We'll be right back after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. It's still the community and the law, brought to you by BWF Solicitors. This afternoon, we have discussed and still discussing exemption from English language and live in the UK test, making a successful application. Remember earlier on, I gave you the scenario of my friend Greg, who had a situation that we looked at, and we wanted you to tell us what he needed to obtain for him to be exempt. So Greg Afonso, he suffered from anxiety and depression for over 10 years. He treats his condition with prescribed medication and recreational activities. His medical condition makes him anxious under stressful conditions. This makes him forgetful and anxious. Greg is applying for British nationality, but is anxious that he will not pass the English language and life in the UK test. So what must he do for the Home Office to waive the English and life in the UK test requirements? And I've given you three options. Choose one and let me know later on. Completed waiver forms and a cover letter from his GP or treating consultant. Completed waiver forms and prescription, and doctor's letter and cover letter from his lawyer. I didn't mention herbalist, so don't do that. We will come back to that. And it also brings into focus our nuggets, which I introduced earlier on prior to our discussion. And we're talking about long-term physical or mental health condition may exempt you from passing the English language and life in the UK test. So we said your GP or treating consultant must always complete the KOLL exemption forms. Explain your condition in detail in a cover letter and add copies of your medical records to confirm that your condition is long-standing. Remember, this is a discretionary provision in the law. Supporting your application with independent evidence is always advisable. The exemption for a medical condition is assessed on case-by-case basis, and this is based on 6 and Schedule 1 of the British Nationality Act of 1981, paragraph 2E. So, well, I'm going to go to the comment section and also on our text message line and all the rest of it to pick up your questions for Anchorman to help us answer. The lines are active 0208 493 7345. 0208 493 7345. You can send the text, as I mentioned, 07399 208 468. Okay. Those of you who have joined us and announced your presence, want to thank you so very much. Siniduma, I've seen you and you're always doing what you do best. You would want people to log on and, of course, announce themselves on the platform. So thank you very much, Tini. I've got somebody on the line, but what I will ask you to do, please go down the volume of your computer, laptop, TV, and let's speak on the phone. I think that will help us so that we avoid the feedback. Okay. Hello.
Hello. Good afternoon.
Good afternoon.
Oh, okay. The question. Hello.
Yes, we are listening. Please go ahead.
Yeah, please. I would like to answer the question that you put there.
Oh, you want to answer the question? that's quite ambitious. All right. Should I? Okay, I won't tell you whether it's correct or not.
I wanted to try and error. Just try.
No, I won't tell you whether you are right or wrong because I'll come back to pick up the explanation so we'll get the correct answer. So go ahead with it. What do you think?
I think it's number 3.
You think it's number 3? What does number 3 say? Let's see on the screen what number 3 says. A doctor's letter and a cover letter from his lawyer. That's what you think Greg should provide, right?
Yes.
Okay, keep it. Your name is? Osei. I'm going to write it down. So when I'm putting up the answers people have brought in, I will include yours. Okay, but keep your fingers crossed. If you are correct, I'll call you back.
Okay. Well, okay. I've got a question to ask.
Yeah, sure. Go ahead.
Okay. I would like to ask if a student dependent got divorced, the marriage collapsed, will the dependent be able to get married again and submit a spouse visa application?
Well, Uncle Ben himself is here, so I will attempt it. Uncle Ben, over to you, please.
Yes, it can. I think there was a confusion. There was some confusion in the community where some people went on social media to say that if you came here as a dependent of a skilled worker or a student, you couldn't marry another person here. And we all know that it's not true because the law hasn't changed. So yes, they can. Okay.
Okay. Thank you.
Okay. All right. Thank you very much for your call. Yes, the lines are active and free now, so you can call in 0208 493 7345. In the meantime, we have some questions on the platform, we will pick them up and ask Uncle Ben to help us. One has pending application with the Home Office as a parent. She has no legal status. She lived with her aunt, who was her financial sponsor and accommodation provider, and provided documents to support the application, and has sold the house and doesn't live with the applicant anymore at her new address. Applicant's passport will be posted to her old address. No access to the old address. If she changes her address with the Home Office, does she need to provide evidence of accommodation for the new address? Any advice would do. This person continues to say that she tried with Royal Mail Redirection Service online, but was required to pay with bank card in her own name registered at her old or new address, which was not possible. So this is the situation our friend is facing.
Well, you must change the address online. So you go on the Home Office website, and then you can change your address on there because you have an account. Or if you don't have an account, they have a portal where you can put in your new address. Sometimes they might ask for a copy of your passport, which you can just upload. If you don't have residency in the UK, very unlikely you will have a proof of address. So that shouldn't be an issue at all. But immediately, they must change it.
So immediately you must change it. Thank you very much for that. Let's go to the phone lines now. Hello.
Hello.
Yes, good afternoon.
Good afternoon, my boss.
Yes, boss. Your Highness, I'm at your service.
Good afternoon again. Thank you to Uncle Ben for his numerous efforts in helping the community. I just want to ask of this.
If you put your phone on loudspeaker, what I'll ask you to do is either put it back to normal and speak through your phone, or lower the volume of your loudspeaker because we're getting some feedback and your voice is very far away.
All right. Can you hear me now?
It's super better now.
All right, good. I just wanted to ask a parent, specifically the mother who is on pre-settled visa, that she needs to do an urgent application for her daughter after giving birth, or can she wait till she got indefinite before she can do that for the child? Because the husband, whom I think is British or on settled visa, is not willing to help them. I just don't know the reason why. But then I wanted to ask whether the mother being on pre-settled count should wait till she gets settled to apply for the child, or there must be an urgent application for the child. Yeah.
Okay. Uncle Ben will answer you.
Well, the child is British, so I don't know why she's going to apply for pre-settled status. She should apply for a British passport for the child. If you're dating someone, you will know their name, you will know their date of birth. That is what she requires. If she doesn't have the passport number, it's okay. She can explain to them, provide his name and date of birth. And the father is not willing to do anything, just do a cover letter and explain. Normally works. It might take a bit of time because they have to do their own background checks. But the child is a British citizen, so don't downgrade the child to pre-settled status. Okay?
All right. Thank you so much.
Okay.
Thank you too for calling. Thank you very much. 0208-493-7345. Uncle Ben is here to help us answer the various questions that you have. You can send a text as well, 073-99208-468. Let's pick one from the platform. Nanachi says, if a child is 16 years and has indefinite, whether through private life or through their parents and being registered, are they exempt from English language requirement? What about age 17, 11 months at the date of the application? Are they exempt as well? Uncle.
Nana Etiahene, I think we're going to soak cane and put you on the table. We have to lash you. This is the easiest question. Listeners and viewers, please answer Nana Etia. The child is 16, another one is 17. So even if it's 17 plus 360 days, they are not 18. So we know there's exemptions for age. Please answer this question for Nana Etia. I think we all know. Everybody's watching it. and we should see that. Nanetia, you must answer your own question. I think you know the answer.
Okay, answer and bring back the answer for me to see if you really know. If you don't know, we'll have to re-educate you on that one. Anyway, remember this afternoon we've been looking at the exemption to KOLL, knowledge of life and language in the UK. Your questions, your comments, and your phone calls are now being invited. The next thing comes in. I think probably you pick up questions from other people
yeah.
and you help put put them forward for them. That's a good one. Thank you very much as well. Parent applying for leave based on British child who doesn't meet immigration status, financial accommodation, and English language requirements. Are they supposed to provide evidence of English language for application to be successful if EX1 applies?
Nana, so once you've mentioned EX1, what EX1 does is it's also an exemption. So the immigration rules have a lot of exemptions. And EX1 exempts you from many things. It exempts you from having a status. It exempts you from accommodation. It exempts you from income. So if they don't have accommodation or they don't have an income, it's not a problem. And life in UK obviously is exempt unless she wants to subsequently switch to the 5-year route. But also remember that when you make an application, they will ask you where you live. They will also ask you whether somebody supports you. It doesn't mean that if you say no, 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 they refuse you. They're not going to refuse you. Because when you look at the mandatory requirements under Appendix EX1, it exempts you, and even GEN 3.1, 3.2 are also grounds that you can rely on. So it's not a requirement, okay?
Well, Naneja, thank you very much. And as I say, if you aggregate questions for people, that's commendable. And we thank you for that. The number again, 0208-493-7345. Or you can send a text 07399208468. Or you leave it in the comment section down below. Either on Facebook at BWF Solicitors and at BWTV UK. Or on YouTube at BWF Solicitors and same at BWTV UK. Let's keep it going. Let's see what else we have. Francis Chairman, is it possible for a Ghanaian man in the UK to get married to a non-Ghanaian woman who's an Italian, also living in the UK, in Ghana, through proxy marriage? Uncle?
Yes, yes. In fact, we advise our clients who have concerns to go through our customary marriage. Our customary marriage is not proxy, but when you use the word proxy, people understand it better. But our customary marriage, and I had this a report that I did with Professor Woodman, who's a recognized authority on Ghanaian customary laws in the UK. Prior to his death, I think he died about 6 or 7 years ago. We wrote a few reports, and we've always said that customary marriage is not proxy. The reason why it's not proxy is that in Ghana, our marriages is between family A and family B, family of the man and family of the woman. That is the marriage. Mm-hmm. And that is why when you define what a customary marriage is, we look at either the 4 or the 5 ingredients. 1, consent of the family. So if you meet a beautiful, respectful, intelligent, wise woman whom you want to marry, and she says, I want to marry you, and you go to her family and they say, we are not going to give you consent. Under our customary law, you can't marry her. But of course, you can marry her under the ordinance or the registry or whatever. So it's not a proxy marriage, but we all know what a proxy marriage is. It means that physically you're not there. Mm-hmm. So somebody contracted a marriage on your behalf. Well, in that case, yes, that's true. Yes, you can do it. You need to follow what I advised previously, so that we don't have any contradictions, future withdrawals, and future problems. I always advise that you authorize the people who are going to stand in for you, either through a statutory declaration or some other authorization which is verifiable and can always be produced in future if there's a problem.
Francis, thank you very much, and that's your answer. And let's pick up the next one from the platform, we don't have a call yet. Petronella Squas, what is the process of bringing your niece to the UK as a British citizen?
Well, if we look at bringing a dependent family member to the UK, the threshold is very high. So they must be living in a country where they are particularly compassionate circumstances, which makes their exclusion from the UK unreasonable. The threshold is very high. So when you say bring in your niece and you're a British citizen, it's almost impossible unless she's living in the most compassionate circumstances. So, for example, if she's lost both parents, or she's lost one parent and the other parent cannot be traced, there are no other relatives, or maybe she's living in an environment where her safety is not assured, and maybe she's going through a traumatic event, which is caused by those people who are caring for her, guardians and stuff like that. Then you can. The last case I did on this is about 20 years ago. Oh no, sorry, it's about 2 years ago. But there's one I did 20 years ago. This were almost one was actually over 18 and the others were under 18. Their father was a military man who was a very senior military man, and he was an alcoholic who was beating them. And we had a report from the army about his behavior. We were able to bring them. So in that condition, of course, it was a mother and her children. One was older, but we were still able to bring the person. But again, the thresholds are very high. So unless there are extreme compassionate circumstances, it will always be difficult.
Difficult, but not impossible, I want to say, because when you have very difficult situations, speak to the lawyers that know what they are doing, and I will recommend every day BWF Solicitors. Call them on 0208 493 7340, and they will help you. We've got a few more of the questions and concerns to pick up. Charity Mensa comes up with this one and says, my brother came to the UK with care. If his wife did not pass a test, can my brother renew his paper?
Well, I'm not sure. Charity, my brother came to UK with care. If his wife did not pass her test, can my brother renew his paper? Well, if your brother is a dependent on someone who is in the UK with a care visa, I'm not sure what test you're referring to. It may be that they've now come to the 5-year stage where they're applying for indefinite leave. Remember that they both have to pass the English language and the life in UK. So if she can pass hers, that should not affect her if they've done the 5 years, but they're both applying. It's a very, it will be rather unfortunate if somebody's here on a care visa because they have to pass the English language at B1. So I'm not sure. I'm just assuming the question. But please, Charity, if it's my friend Charity, please give us a clarification so that I can give the proper answer. Because if somebody is here on a care visa, they already are on a B1 or have a university degree. So I'm not sure which test you're referring to. Please let us know.
Well, Charity, if you can let us know, whilst we still have time, you may probably want to call in and quickly give that further explanation as Uncle Ben is asking for. Let's pick up another one. And Krisha Aneka says, have a concern. Don't worry, you've come to the right place. I came to the UK with a 3-year skilled worker visa, but apparently the company's license was revoked within 3 months of work. Unfortunately, I did not pay any realistic taxes. How can I apply for an indefinite leave to remain if I get a new certificate of sponsorship, Uncle?
Well, so we know that to qualify for indefinite leave under Appendix SW, you need to have either been a dependent or worked for 5 years. Mm-hmm. So once you work for 5 years, in the 5th year, if you come to the end of your 5th year, you can apply for indefinite leave. Your current sponsor must write a cover letter to say they still need you to work for them. That's it. Historical, when they look at it, they can make a lot of trouble. But my experience is that they hardly go back 3 or 4 years. They look at the current COS you have and the letter from your sponsor.
Well, Anelka, thank you for that. And I hope that you can get further help if you really want. Speak to BWF Solicitors. Let's take the very last one. We'll take a break, and when we come back, we'll look at our quiz, and then um, we see who got the correct answer. We'll draw the curtains down after that. Quite different point. You say you on a graduate visa that would expire in December 2026. If you got married to someone in the to someone on the EU pre-settlement scheme visa, will that change your status, Uncle?
Yes, it will change your status from that of a postgraduate visa holder to that of a spouse, and you'll be given 2.5 years.
Straight and simple as that. Thank you very much. And with that, we want to say thank you to BWF Solicitors. Please watch this message, take the details, and remember you can visit them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208-493-7340. Those of you in Ghana, the Ghana office is on 055-589-5959. And in emergency situations, +447712761884, +447712761884. You can find the numbers at the bottom of your screen. BWF Solicitors are trusted partners when it comes to the law. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay, lovely people, we're back. Where am I? Okay, yeah, I'm here. We're still live on BWTV, and the program is the Community and Law. And this afternoon, as we have said repeatedly over and over again, we're looking at exemptions to life in the UK and the English language test. I will want to say that if you have any situation and you need support with that, especially when you think that you qualify for exemption, you can speak to BWF Solicitors and they'll help you. 0208-493-7340. And I believe they don't teach the English language, they don't teach the life in the UK, but they can signpost you to where you can reliably find a place to learn it and pass quite well. For English language, my own very own Namayati will help you write that as well. You always hear from her this time around on Fridays on our network, and I think she still does her Sunday, the Mighty show. So get in touch with her, and she will be able to help you. Prior to that, I gave you this by way of our nugget, and what I asked you to look at is what can qualify you for the exemption. You can request an exemption from the knowledge of English and life in the UK requirements if you have a long-term physical or mental health condition that permanently prevents you from meeting the standards for learning English or taking the life in the UK test. You must provide evidence from a medical professional using a waiver form, that is the form waiver KOLL, which shows how your condition impedes your ability to pass the test. Your GP or treating consultant must always complete the KOLL exemption forms, explain your condition in detail in a cover letter, and add copies of your medical records to confirm that your condition is long-standing. This is a discretionary provision in the law. Supporting your application with independent evidence is always advisable. The exemption for medical condition is assessed on a case-by-case basis. So, my friend Greg Alfonso, who suffered from anxiety and depression for over 10 years, treats his condition with prescribed medication and recreational activities. His medical condition makes him anxious under stressful conditions. This makes him forgetful and anxious. My friend Greg is applying for British nationality, but he's anxious that he will not pass the English and life in the UK test. So my question here is, what must he do for the Home Office to waive the English and life in the UK test requirements? So I've given you three options. My friend Osei called in and said it was a third one. I'll go through them. The first one is he needs to provide a completed waiver form and a cover letter from his GP or treating consultant. He must obtain completed waiver forms and prescription. Or the third one, which my friend says selected, that he needs to obtain a doctor's letter and cover letter from his lawyer. Which one is correct? So I'm waiting for your answers. Let's see what you have brought, and then I'll go over to Uncle Ben to help me answer that correctly. Ofayao says the answer is number one. He needs to obtain a completed waiver form and a cover letter from the GP or treating consultant. Seth Robe thinks it's number three, doctor's letter and cover letter from his lawyer. Okay, Seth, thank you. Emmanuel, Ima says number three, doctor's letter and cover letter from his lawyer. Thank you, Ima. The next one, Kojinia also thinks it's number three, doctor's letter and cover letter from his lawyer. We go to Rita Kodom, and Rita thinks it's number two, completed waiver forms and prescription. Okay, thank you, Rit. Collins upon says doctor's letter and cover letter from his lawyer. Oh, okay, let's see what Bahima also says. Needs completed waiver forms and a cover letter from his GP or treating consultant. The next one from Priscilla Drew is number one as well. Priscilla, thank you for that. We go to Tilly Duma. Tilly thinks it's number three, doctor's letter and cover letter from his lawyer. Would that be BWF Solicitors? I don't know. Let's pick up Paula Quarantine's answer. Completed waiver forms and prescription. Who else? I think for the sake of time, I would pick up Naneo as the last one. And he says number one, completed waiver forms and a cover letter from his GP. Well, before Uncle Ben comes in, let me read the nugget again. Maybe that answers it. You can request an exemption from the knowledge of English and life in the UK requirement if you have a long-term physical or mental condition that permanently prevents you from meeting the standards for learning English or taking the life in the UK test. You must provide evidence from a medical professional using a waiver form which allows or which shows how your condition impedes your ability to pass the test. I won't say anymore. Uncle Ben.
So, we've gone through that today.
Yeah.
And for people who were not with us at the beginning, what we looked at is the law, what the law says must be done. And then we've also read the guidance notes, because the guidance provides further information, which helps us to understand the law a bit more. The law is very simple. It says that caseworkers should or may consider where they feel that it's okay, they should allow you or they should exempt you if you're suffering from one physical or mental health condition that prevents you from studying and passing the test. So that's that. When you read the case law, so there's no more information under the law, but when you read the guidance notes, it says that you must complete the waiver form. Although we know from the guidance note, it says that if you don't complete the waiver form, they should ask you to complete it. So you need to complete the waiver form. Again, when you read the guidance notes on the waiver and the waiver form, it advises you to add your medical notes or a letter from the GP explaining what the diagnosis is and what the prognosis are. So that's very clear. Lawyer's letter is always a must. When we make applications, we always write cover letters. A prescription form, prescription itself is not complete medical notes. So if it included other things, then that's fine. But your medical notes and the waiver form is what you need. The waiver form will always come with a cover letter from the GP. And sometimes we ask, because the questions on the pro forma are very restrictive. So sometimes we ask the GP further questions, and then they do that. So the answer for me will be number one.
Completed waiver form. Is it frozen? Oh, okay. Well, I'm so confused now. Don't worry. I will find it. Well, argument says it's number one, yes. And the reason is that applicants must present detailed medical evidence highlighting the diagnosis, treatment history, prognosis, and linkage to functional incapacity to take and pass the test. The Mohammadi judgment confirms that under the British Nationality Act 1981, look at me bragging like a lawyer, 1981, and Home Office policy, a waiver of the knowledge of life and language requirements demand detailed medical requirements. That evidence showing that a qualifying condition makes it unreasonable to impose language or life in the UK test on the applicant. So an applicant's mere failure to pass these tests is not sufficient. You make sure that
we should go to the case.
The case is petition of Shoshi Mohammadi for Judicial Review Court of Session 2025.
Yeah, I sent it to you.
I don't know whether we have the case.
It's case mine.
We may want to go into that. So I will have a lot to brag on because I quoted the case. That is so that you can use. So those of you who said number 3, I think you apparently didn't get it correct. Okay, I would have called you back if it was correct. Let's accept all the cookies and let me quickly look into this.
If we run down, let's go down a bit. Let's go. Legal reasoning.
Legal reasoning.
Legal reasoning.
Yeah.
So is it the court began by setting out the statutory framework, Section 6(1) of the 1981 Act requires satisfaction of Schedule 1 condition before naturalization. Paragraph 2 allows waiver if because of the applicant's age or physical or mental condition, it will be unreasonable to expect him to fulfill the language and life requirement. Home Office policy explains how discretion must be exercised and when medical evidence should be requested. Lord Lake stressed the distinction between A, the applicant's factual inability to pass the test, and B, a qualifying condition rendering it unreasonable to impose them. This prevents waiver on purely factual grounds, preserving the integrity and purpose of knowledge. It goes on. Petitioner's GP form reported amputation, chronic pain, depression, low mood, poor concentration, memory issue. Kweku, if I had this from a GP, this guy will be successful.
Yeah.
Because everything they've said there, look at it, chronic pain, reported amputation, depression, low mood, especially poor concentration, memory issues, and migraine, but failed to identify when conditions were diagnosed. Describe treatment or their effectiveness or clearly defined mental condition causing unreasonable. Policy requires original current medical evidence in specific form. In this case, they asked him to bring the form. He didn't take it. That is why they refused it. And he went to the court, and the court sided with the Secretary of State, the Home Office. Let's go down. Impact. The decision clarifies and fortifies the evidence threshold for KO waivers. Applicants must present detailed medical evidence pinpointing diagnosis, treatment history, prognosis, explicit linkage to functional incapacity. Authorities are entitled and indeed required to request further evidence where initial material is generic or undetailed. Again, emphasis is on detailed. And 2, it should be person-specific, not generic. Future judicial reviews will likely reinforce the separation between inability to pass and legally relevant unreasonableness, ensuring consistency in waiver decisions. Naturalization applicants with disability must ensure their medical evidence addresses all policy questions. Administrative refusal on evidential gaps will survive judicial review. And that is why, in this case, I don't know why he didn't provide the detailed evidence, but you must always link. And that's why I said you also need a lawyer to guide the GP, and the lawyer must also write a cover letter. Thank you.
Well, thank you very much, Uncle Ben. And that brings us to the point where I go back to his desk for, I think it summarizes it well enough. But, well, tradition cannot be broken. Uncle Ben, what did you do this after?
So today we've looked at how you can apply for exemption under the requirement for English and life in the UK. We've also understood that the law itself is very specific. It says you must have a mental or physical condition that prevents you from preparing and passing the exams. The guidance says that if you can show that it's unreasonable for you to pass, then again, the caseworker who has a discretion in this matters must passport you and put you on the exemption. We've also seen that the guidance notes also introduce some high threshold. And we're saying that where the law gives you a simplified requirement and the guidance note gives you an advantage, both are to your advantage and they cannot introduce a higher threshold. So what is the moral lesson? The moral lesson is that if you're struggling to pass your language and life in UK because of mental health issues, anxiety, depression, memory loss, forgetfulness, physical condition that prevents you, example is deaf, impairment of speech, so a stammerer, for example, could pass. These are some of the conditions, not all of them. But if you believe that your condition is such that it prevents you, then you can go to your GP. If the GP is not helpful, there is a portal online, which I'm not going to share, and you can go on that portal, go and see the doctors, and they have to be GMC registered. They should be members of the General Medical Council of the United Kingdom, and they will assess you and prepare a report for you. In addition, they will ask for medical file from your GP. If they don't, I will suggest that you tell them to prepare this should be a condition that you've already reported to the GP. And if it's noted in your medical file, then you can disclose those. Not all your medical file, but a specific medical evidence that relates to your particular condition. Thank you very much.
And thank you very much, Uncle Ben, for your time. Thank you very much, BWF Solicitors, for the opportunity and also helping us to do this every Saturday on the community and the law. And to you out there, I want to say thank you so very much for your time and also sticking with us. Having faith in us is so precious to us, and want to invite you to come again same time next week to join us for another edition of the community and the law. First off, Uncle Ben, thank you very much. Again, BWF Solicitors, thank you very much. Auntie Cynthia, happy birthday to you, and also to you out there, thank you for your time. My team has been Sheila Ankara, Padmo Dodu, and the indefatigable Professor Ade. I'm also Frimpon. Have a good day.